Hi, I'm Mark Biernath. I'm an estate planning attorney here in the Atlanta area. In this section, we're going to be concluding our discussion on guardianship and conservatorship here in Georgia. And we're going to take a closer look at what rights are removed by the court from the ward and what rights are retained by the ward. We're also going to take a look at some of the common misconceptions individuals have concerning guardianship or conservatorship here in Georgia.
Rights that are taken away from the ward. The right to enter into marriage is taken away. The right to enter into contracts is taken away. The right to determine where to live is taken away. The right to consent to treatment is taken away. They are still supposed to be able to participate in the decision if they're capable. But they will no longer have the right to consent to treatment. The right to revoke a revocable trust. That wouldn't be an issue. Rights not lost. The right to refuse treatment. And this is, a major problem, especially in the mental health world. Parents they call me, say mental health issues are critical. And most people don't feel comfortable doing that themselves because, it is more complicated to show that they're not capable of making a decision. Because for the most part, they are able to make decisions. It's just when they're in a period of time, an episode, where they can't do it. And so it is more difficult to meet that threshold. So oftentimes lawyers are consulted for that. Trouble is, mom and dad don't realize that even if you are guardian, that doesn't mean you can force them to comply with their medication. They have the right to refuse treatment. The ward has right to independent legal advice, the right to contest the guardianship. The ward always has the right to say, I don't need this guardianship anymore. They also have the right to vote, which is kind of funny. You're legally incapacitated, not capable of making significant responsible decisions, but you can vote.
In this country, that makes sense.
What happens when they're already married and then the court decides that they're incapacitated?
The marriage doesn't end. They're not allowed to enter into a marriage contract. So if they're already in a marriage contract,
if they wanted to get divorced.
If they wanted to get divorced, they could not make that decision. And believe it or not, I've had some people try to get guardianship over their wife, basically to keep them from divorcing. Those are fun phone calls, I'll tell you that.
That's going to be bad. If she wanted to get out of the marriage now, she couldn't.
She couldn't. The guardian could do it. Well, then no. Unless someone else goes to the court and says, she's expressed this to me, we need to, there's a conflict of interest here, and then another person gets appointed. So, but yes, but that, maybe once a year I'll get a phone call, my wife's crazy, she wants to divorce me. It's like, well, she may or may not be crazy, but that's not going to cut it. But the right to vote can be removed, but the judge has to specifically include that. And I had one situation where the ward had expressed certain political views while we were waiting for court to start, and with nobody asking the court to remove the right to vote, the judge included the right, removing the right to vote. So I thought that was kind of funny.
When you fill out a voter registration, it asks on there, one of the questions that it asks, because I had to go through this with my daughter, are you an incapacitated adult?
That's interesting.
To something of that effect. Because I remember she and I had this conversation and me explaining to her if she checked yes that she would not be able to vote.
I don't know about that.
I don't know about the registration.
But it would have to do with other things that they use the voter registration.
That could be, that maybe for jury duty, that she would not be in the pool.
Now when I called and inquired about it, if she checked yes, she could not vote.
That's interesting, because the law specifically says just the mere fact that you have a guardian does not remove the right to vote. The order has to specifically say that the right to vote is removed.
I mean, this was 3 years ago, so.
Okay, and the new guardianship code is about 2 years old, so. But there's some common misconceptions with guardianship. Number one, cannot force an individual to take their medicine. You are permitted, however, to use all your parental influence to encourage them to comply with treatment and all that. But you don't need to be guardian to do that. You cannot make them better or more compliant by being their guardian. However, I have had some people tell me that it's worked to tell them, well, I'm your guardian, you have to do this, and they do it. So in that respect, maybe it works, but in reality, no. Being their guardian is not a magic bullet. It's not going to make them better. It's not going to make them more compliant. Does not affect access to benefits. It may actually make it easier because you are able to sign all the different forms that need to be signed. Also, you will automatically be the representative payee if you are the guardian, that kind of thing. One other issue here is if an adult is declared incapacitated, if that person goes missing, the police get involved right away as though it is a missing child. If it is an adult who's missing, you got 3 to 4 days before they will actually consider the person missing. And this is huge if you've got autism or Alzheimer's or anything like that going on where they are susceptible to wandering off. Again, a small community where the police know everybody or there's personal contact, they probably won't wait. But if you're in like Metro Atlanta and you call 911, they're going to say, well, how old are they? 19? It's like, maybe they just went to Florida for the weekend or something. And you're like, no, you don't understand. And then they'll ask, well, are you his guardian? And then you have to say no. And then convincing them to do something faster rather than slower is more difficult. Guardian is not liable for acts of the ward solely by being guardian. We actually have a law that says that very clearly. However, that being said, you may be liable for other reasons, but not because you're the guardian. One case that actually occurred here in Georgia, a guardian gave their ward a gun. Probably not the wisest decision. They were not liable simply because they were the guardian. They were liable because they gave somebody that they knew and had information that should not have had a gun, they gave them a gun.
So we've looked at some of the alternatives there are to guardianship, which would involve using powers of attorney, a healthcare power, or the Georgia Advanced Directive for Healthcare, as well as some of the other tools that can be used in a pre-planning context, such as a revocable living trust. If you find that you're not in a situation where the individual you're concerned about can take advantage of some of these alternatives, you may be left with no other alternative than seeking guardianship or conservatorship for that individual. We hope that you find this information helpful. Now, you may be having some questions, as did the audience in Somerville, and we've compiled some of those questions into a clip as well, and that will follow this one. So please join us for that as well.